Well, joining me now is legal analyst and trial attorney Misty Marris. Misty, it's so great to see you. Before I get to my other questions, so I want to ask about this feed. The feed is not up. Laura tells us it's because the judge doesn't want any potential jurors tainted. What is your reaction to that?
So there was a hearing yesterday that the judge held with both sides, the prosecution and the defense. And the arguments from the defense were to make this hearing actually publicly available and have it be streamed and not be a closed hearing, which was a surprise because from the beginning, it had been the defense who had requested gag orders and to keep a lot of what was happening in the legal case outside of the public eye. So during that hearing, the judge ultimately determined that because the hearing was going to be very sensitive, it's going to be talking about DNA evidence, it's going to be talking about arguments relating to the law enforcement investigative practice that was used in order to identify Kohberger. All of that is going to be at issue in the hearing and might never make it into the trial because that's what this whole hearing is about. So I was not surprised to hear the judge take that position, especially since the closed doors on this case, the gag order may have even gone too far from the beginning, but was pretty much conceded by the defense at the time that that was the best way to get a fair trial for Kohberger.
All right, so Misty, let's get into this. What is the strategy of Kohberger's team asking for this key evidence to be dismissed? I mean, would that mean that the prosecution really wouldn't have much of a case?
It would change the game tremendously if some or all of this evidence were to be excluded. And no surprise to me that the defense was taking this strategy and avenue to try and get some of this evidence out of what would be admissible in court. So there's two different standards. There's what's collected during the investigation. There's what's collected via a warrant. And then there's what actually makes it in front of a jury. And the reason I say that is because in any case like this, especially where there's DNA evidence, there's going to be challenges not only to the evidence itself, but to its collection. And so here, it's important to understand the three areas that the defense is challenging, although what they're looking to exclude from the courtroom, DNA, phone records, electronic records, basically everything that had been gotten in the investigation by law enforcement, everything that makes up the case. The arguments, three buckets. Number one, the methodology, genetic genealogy, as Laura just laid out, investigative genetic genealogy. Is that methodology sound? Can that come into the courtroom? They're challenging the methodology itself. Number two, how the warrant was actually gotten by law enforcement. They say that police officers who made arguments to a judge to get those warrants, to search his home, search his car, all of that, that they actually misrepresented facts to the court. So those warrants themselves are invalid. And then the third relates to what the prosecution has turned over thus far in the case. And the defense says it was insufficient and prejudiced Kohberger. And the relief that they're seeking is to toss some of that evidence so it would never make it into the courtroom. This is common in any defense case, especially when forensic evidence is really at play in the trial.
So, Misty, how do you think the judge will rule? And again, we do continue to see all of these filings, we see all of these motions. Do you think this trial actually begins in August?
So it's important to note that one of the arguments the defense will have is that especially if the genealogy, the genetic genealogy itself, that methodology, if they're successful on that argument, or if they're successful in the argument that those warrants are invalid because the law enforcement presented or mischaracterized facts to the judge, and therefore the warrant would never have happened but for those misrepresentations. That's what we call fruits of the poisonous tree, Nicole. That would mean that anything relating to that investigation that was derived from those initial, from the DNA or from those initial searches could be thrown out. I don't see it going that far. That being said, we don't know the basis for that challenge about what was communicated to the judge by law enforcement in order to get those warrants. We don't know those arguments that are at play in the court. I suspect the argument about the methodology of genetic genealogy, although it's a new practice that's likely to be unsuccessful, that has been admissible in other cases. The question is, was there something that was told to that judge when that warrant was being sought that was not true? and that they knew was not true at the time? That's going to be the critical question. And Nicole, if all that evidence is thrown out, the case changes dramatically. Remember, one of the key issues here, the genetic genealogy identified Kohberger, but then once he was arrested, there was a swab, a cheek swab. And so his DNA is actually directly matched to that knife sheath to a degree where it's really unable to be controverted. That could be thrown out as well. So this hearing is actually the most consequential in the case and is going to shape both the prosecution and the defense and how it proceeds into the courtroom.
Wow. All right. We will certainly see what happens. Great information there. Misty Marris, thank you.
Thank you.